Good morning. The cases foisted against BBIPs, ministers, executive officers under Prevention of Corruption Act, amassing wealth disproportionate to their incomes, are time and again being gained this way or that way by finding some loopholes, technical loopholes. Here, the Supreme Court, after Lalit Kumari case, issued a direction that for certain offences, preliminary inquiry should be there. Now, that judgment also now distinguished. So, you can now very well file complaint directly to the CBI and insist the CBI to file FIR even without preliminary inquiry by citing this judgment. This is AR 2021 Supreme Court 5041 Central Bureau of Investigation versus Tomandru Hanna Vijayalakshmi alias T.H. Vijayalakshmi. And this officer happens to be in Tamil Nadu also. So that only facilitated him to earn more income because this is a good field. See, the ratio is Delhi Special Police Establishment Act 25 of 1946, Central Bureau of Investigation Crime Manual 2005, para 9 and 1. This should also be gone into if you are conducting CBI cases. This crime manual, etc. It's not mandatory before registration of FIR under CRPC, Prevention of Corruption Act, or even CBI manual in case of information received by CBI through a complaint or a source of information. It discloses commission of cognizable offence. It can directly register as a regular case instead of conducting preliminary inquiry. Said formulation does not take away from valuable of conducting a preliminary inquiry in an appropriate case. So they have given some distinct these things. Then another Prevention of Corruption Act, Section 13(1)(e), 13(2), Penal Code 109, quashing of FIR. Accused Commissioner of Income Tax allegedly possessing assets disproportionate to her known source of income and co-accused and her husband abated said offence. High Court inquired into material adduced by the accused person and compared it with information provided by CBI in FIR and their counter affidavit. Thereafter pronounced a verdict on merit of each individual allegation raised by the accused by relying upon documents filed by them. High Court justified said excess on the ground that CBI not conducted a preliminary inquiry. CBI need not hold preliminary inquiry mandatorily. High Court, while quashing FIR, conducted a mini trial to absolve accused persons. So, order of High Court was quashed. They have discussed so many cases, particularly Lalit Kumari case, wherein preliminary inquiry was directed to be hold on before filing an FIR. This is what happening in Tamil Nadu State Police also. I have already given suggestion that if you are afraid of statistical crime rate, crime registration, you have register an FIR stating that for want of preliminary inquiry, you have some FIR-A, FIR-B for that if you simply hold a CSR without examining any evidence, nothing, mechanically they are referring them at and the courts, high courts, because of rush for their hands are also tied to dispose and allowing us to knock the court again and again. For some cases, without assistance of police, we may not be in a better position to collect evidence. Therefore, I sought state government, I gave a suggestion to state government of Tamil Nadu, hoping that that suggestion may be looked into, that if the complainants want to engage private investigating agency through their advocate, that may be approved by the head of the department of the district police officials by properly amending CRPC, mandating providing that provision for the complainant to have investigation, and the police must assist the private investigating agency also to adduce further and proper evidence. This is one part is over, you have to go through all those things. My another part is, it's only my question to state judicial administration. See, one thing, constitutionally, Chief Justice of Tamil Nadu, Collegium Advocates, full court, everybody is entitled to give directions, whatever it may be. So far, functioning of court proceedings are concerned, administrative control and subordinate judiciary control, because other provisions of 227 article as well as 482 CRPC is there to control the subordinate courts. Absolutely, we have no grievance. Same time, the High Court is also having plenary power to say that we will hold this sort of practice, this sort of hearing, only virtual hearing and physical hearing. That is also exclusively the direction, depends upon the requirement and other things. We are not interfering with, we are nobody to interfere with, we just salute. But other aspect is concerned. The administration of other filing process, court of record, it is absolutely vested with the Registrar General. Therefore, my question is, when you are preventing advocates, clerks from entering into registry office, it should be duly, by the procedure duly established by law. You are preventing us showing the COVID. Let us satisfy whether you have done that under the provisions of that particular act, which facilitate the executive authorities in other area of departments, and including Chief Secretary, they are consulting a panel of experts, doctors, health ministers. Therefore, kindly clarify whether you have got that much of facility, consultation. Otherwise, you have to do it that way. You cannot act arbitrarily. That is my best submission. Best wishes.